for the appellee, I know we have multiple law firms for the appellees. Have you all discussed amongst yourselves how you would like to divvy up your time?
We have, Your Honor, Brandon Crosland representing Appellate NSCSE Siesta Key. Spoke with Ms. Hine prior to it. I would like to take 15 of the 20 minutes and she's 5 minutes.
Your Honor, I represent the fractional owners as individuals. I probably won't have anything to say, if at all, in 2 minutes.
Okay, well, maybe figure that out amongst yourselves.
That's coming from my five.
All right, counsel.
Good morning, Your Honors. May it please the Court. I'm Dan Lobeck, attorney for appellants, the SK Association, and one of the individual owners. No wrong shall be without...
Before you
Yes.
start, did you wish to reserve any time?
I'm sorry, 5 minutes for rebuttal.
Very good.
Thank you, Your Honor. No wrong shall be without a remedy. Common legal maxim cited by the Florida Supreme Court, other Florida appellate court decisions. And Your Honors, if there was ever a wrong in search of a remedy, it's the scheme of condominium development at issue before the court today. This is a scheme where the developer, in the overriding controlling master declaration, has perpetually, without any obligation of assignment, reserved virtually all the fundamental rights and controls over the condominium property. The right to determine the annual budget, all the expenses, the assessments against my client's owners and all the other owners. We're paying 75% of the shared area expenses, determined with very little discretion by the developer, and we don't even have the right as owners to inspect the books and records or attend meetings at which those matters are discussed and determined. The developer has the overarching right to set standards with regard to management, maintenance, other policy, without constraint. Has the right to determine the name of the management company, which effectively is a veto over who manages. And the Condominium Act, Your Honors, is replete with rights of unit owners in a condominium. And my clients have none of those rights whatsoever. In my 39 years of specializing in condominium law, association representation, I've never seen a scheme as inequitable as this. And it violates numerous provisions of the Condominium Act. One of our key points is 718.3023, a provision of the Condominium Act which states that no provision of a declaration or other provisions that provides for the operation, maintenance, or management of a condominium or property serving the unit owners of a condominium, clearly what we have here, any such declaration provision shall not be in conflict with the powers and duties of the association or the rights of unit owners provided in the Condominium Act.
Well, let me ask you this.
Yes, Your Honor.
The relief you requested is extraordinary. I think at one point in the proceedings below, you conceded what you're asking for is extraordinary. I mean, you essentially want to either merge two condo associations or wipe them both out and start a new overarching one. I might want to focus a little bit, not on that kind of broad sweep that you all are laying out here, but maybe more on the discrete problems that kind of seem to be underlying all this. Walk me through what exactly would prohibit or prevent SK2 from simply bringing a deck action or a challenge under 718.3023 when or if the developer or any of the appellees were to violate that statute by a decision that they make or by an assessment, what have you. Why can't you just bring the lawsuit then and bring it before the court?
Well, Your Honor, this is the proper time to do it. This is a broad appeal to the declaratory powers of the court, the equitable powers of the court, to bar the implementation that you describe in any instance.
Well,
if we had to sue,
what you're asking is to prevent it on the front end from ever happening. What I'm asking is is there any prohibition against you all from enforcing 718-302-3 after a violation occurs?
That would be a waste of judicial resources because we'd be in court every day, Your Honor. Because these are constant assessments, constant liens. We had liens filed against our units, ended up getting dismissed by the circuit court on other grounds. But we consciously decided to attack the entire scheme of governance. And Your Honor is right. We're seeking extraordinary remedies. The trial court was right about that, using that word. But this is an extraordinary injustice, an extraordinary scheme of development. Again, I've never seen anything like this. And the statute I just recited, Your Honor, I happen to be familiar with it because I wrote it when I worked for the state back in the late 70s, and it was specifically designed to prevent schemes like this. It would be untenable for us to have to litigate each and every offense, each and every assessment, every rule adopted by the developer, every exercise of power by the developer. The only way to remedy this extraordinary offense is by an extraordinary remedy.
See, actually, I mean, you could make an argument that, in fact, the very situation that you're describing, having to seriatim litigation and having to constantly go back and forth, and both sides expending enormous attorney's fees, would provide a powerful incentive for everybody to get together and work out a comprehensive resolution to what you're describing, right? I mean,
if it were, Your Honor. We have attempted that repeatedly. I know that we're going beyond the record here, but, you know, we engaged in mediation.
No need to go beyond the record, but it seems to me that you know, you're pushing equity here and kind of bracketing aside the statute of repose problem that I think you all may have to work through. You're pushing equity here, but it seems like there are some resolutions that could come out, you know, if indeed what you suspect would come to pass, which is, hey, listen, every time, you know, you all, the master, you know, SK1, every time you all move and do anything that even smells like a violation of 718-302-3 or any other condo deck, we're going to sue, and we are going to basically be some poor trial judge's worst set of children that they're going to have to manage. Eventually, that gets resolved, don't you think?
Well, Your Honor, it doesn't, because this has been litigated. The scheme has been litigated.
Well, the scheme has. What I'm suggesting is individual actions, because I don't think that you know, even if you lose here, does that necessarily mean that you lose the right to challenge these you know, if they take some untoward or improper or unlawful action, do you necessarily lose the right to challenge those individual actions as they arise?
With respect to the authority for those actions, yes, we do, Your Honor. Because even if this is PCA'd, and I hope it's not, because I think this is a case of great public importance, developers need to be told they can't replicate this scheme across the state. And there are important statutes to clarify as set forth in the brief. But if this is adjudicated against my client, we can never again raise the inequity of the scheme, the illegality of the developer's reserved rights. We simply have to attempt to parse the propriety of each individual act on its merits. For instance, is it a valid shared area expense? Not does the developer have the right to determine if it's a shared area expense. And, you know, that's going to be each budget, each year, each special assessment, because there's authority for that, ad infinitum. And we would lose our strongest point, Your Honor, which is that this is contrary to law, contrary to equity. And I would point out again that our strongest argument, 718-302-3, was not even adjudicated by the trial court. That's a basis to compel remand if there ever was one. Overlooked. And in part because of this statute of repose argument, which Your Honor just raised. That statute of repose is isolated to 718.11010, one of our many legal grounds for challenging this development scheme. In fact, that only goes to whether the condominiums should be merged because there were flaws in the original creation of the condominiums which require merger to correct. And the statute of repose only applies if we are, in our third amended complaint, seeking a judicial declaration that the condominiums were not validly created to begin with, that they don't exist, challenging the existence of a condominium. And we withdrew that very quickly once the statute of repose was raised in response to an earlier complaint, and said, we're disavowing that. We're not seeking a declaration that the condominiums weren't validly created. We want to correct errors, which 17.110 allows after the 3-year statute of repose.
Well,
But
your
yes.
error-correcting mechanism is to essentially wipe out a corporation or to merge them.
Well, the corporations would continue to exist, and the
One of them
appellees...
wouldn't do anything, right?
Well, SK2 right now has no authority, has no control over anything. Even our own balconies are shared areas that the developer determines the expenses of. So to say that a shell corporation was created, that's the offense we have today with the current scheme. And to have a master association in which all the owners have a right to participate, to inspect records, to go to meetings, to elect directors, is the kind of scheme which you normally see when you have 2 condominiums sharing property. It's not inequitable. It is a situation which comports with the law, and as one of the remedies, we would urge upon remand that the trial court be directed to consider, or just merging the 2 condominium associations. They continue to exist, but they continue to exist under the law in an equitable manner, or merge the condominiums.
I'm curious about one argument that you made in your briefing. I think it's your 8th issue on appeal, about the propriety of the adoption of the First and Second Amendments. I think the argument runs that these weren't necessary to the development of the condominium because the condominium was already fully developed at the time that they were unilaterally enacted by the developer. You do indeed allege that in paragraph 61 of the Third Amendment complaint, but what I'm a little bit troubled by and what causes me concern about that issue that you're raising now on appeal is it doesn't look like you ultimately asked the trial court as a discrete remedy, hey, declare just the first and second, putting aside merging these corporations, putting aside, creating a new overarching governance scheme. At a minimum, you should declare that the First and Second Amendments were invalidly enacted. I don't see that in the pleading. Was that raised independently in any way?
Well, I believe in that portion of the Third Amendment complaint, Your Honor, we do ask the court to exercise its jurisdiction to declare that those amendments were invalid. But it's a very minor point, Your Honor, frankly, because
I didn't see it in count 1. I mean, it looked like the relief you were seeking in count 1 was strictly kind of the broader remedy that you've been advocating for, not the kind of discrete, hey, just strike these 2 amendments.
I thought we had pled it. If not, that's error on my part. But again, that doesn't go to the gravamen of the case, which is something that's just not equitable, not fair, completely violates several provisions of the Condominium Act. And in particular, I'd like to draw your attention to another provision of 718.302, which is 718.3021. And the appellees have argued that the court did address 718.3023 because it addressed 718.302. But the only part of 302 that the court addressed was 302.1, and referred to dicta in an appellate court decision that says that 302.1 only applies to contracts for vending machines, management, and the like. And I would just ask Your Honors to actually look at that statute, because it doesn't say that. There's an or, and there's a comma. And it does specifically state that any provision in a declaration, not entered into by the association, the developer does that, must be fair and reasonable. And so to the extent that this court can give clarity to the law, can make that appellate decision no longer hold sway because it is contrary to the statute. You can depart, obviously, from a sister district court, but to put breath into that statute for what it means, that declarations must be fair and reasonable, and this declaration, this master declaration, clearly is not. I obligated my clients to pay 75% of the expenses and have 0 rights intended for condominium unit owners by the Condominium Act. There's another case that's been cited by the appellees, which states that under that statute, the only remedy, if it's not fair and reasonable, is to cancel the contract by 75% of the owners. Now, for one thing, we don't have 75%. We maybe barely do. I don't recall how the percentages work out. But the statute itself, again, has a comma. And it states it has to be fair and reasonable, comma, and may be canceled by the owners. And we've cited the rules of construction that say those are separate things. As a matter of fact, a footnote in the Hastings case says they are separate things, in that it doesn't have to be shown to be fair and reasonable in order to be canceled.
Counsel, you're right into 5 minutes if you want to keep going.
Thank you, Your Honor.
May it please the court. Brandon Crossan representing Siesta Key LLC. Throughout the course of 5 different complaints, the appellants attempted to challenge the known, established, and proper plan of development at the resort. And finally, after those 5 complaints and after cross motions for summary judgment, the trial court entered final summary judgment in favor of the appellees. That should be affirmed for 3 reasons. First, the plan of development was known, it was established, and it's entirely proper. And this effort to convince the court to now apply a fair and reasonable standard to governing documents at a resort and a condo development is entirely improper. While this court's review is de novo, the standard in which this court must look at those covenants that run with the land, and that's what a declaration is, the only way it can reform those documents or challenge those documents is to find that they're either wholly arbitrary, violative of public policy, or infringing on a constitutional right.
Mr. Crossan, can you help me understand kind of because I looked in the record and all I found were like plats. I didn't really see like a good front picture of the building itself. But I gather that this is kind of a mixed-use building. It's got some commercial. It's got sort of a first phase, the 11 units, and then it's got the other 33 units. It seems pretty clear there's fractional owners, obviously. There's timeshare that's going on here. Is the timeshare nature of ownership strictly demarcated between the two?
Yes.
Between SK2 and SK1?
So I actually got the chance to drive by this, but it's one building. It's 44-unit residential building on Sarasota Beach. There's a front desk, there's a driveway, garage, pools, and all that. SK1 is 11 of the 44 residential units. Those units were specifically identified in the survey. And what I don't recall, and I'm not sure if this is your question, is are all the timeshares on the first floor, or are they mixed in? I know that I think when I've looked at the survey, they're mixed into the different 44 units. But it's all one building with multiple floors.
Okay, so this is not a situation then where it's developer decides timeshares are going to be kind of treated one way, permanent ownership going to be treated differently. That is not the case here.
No, and I think maybe the background a bit on the timing helps is this resort was built in 2009 and SK1 was declared to the condominium form of ownership as a fractional or timeshare. By declaring those 11 units, that initial developer, Triton, I forget the full name, but Triton was the initial developer, had financial issues. It went under. In 2011, it assigned the developer rights to my client, who looked at the market at that time and determined that whole condominium ownership was the way to move forward in this. But to do that, my client looked at the governing documents and said, well, SK1 and its owners have been operating this resort with developer-owned entity chipping in for the cost. But there's all these common elements, the hallways, the pool, the garage, and all of that. They've been tasked by the governing documents to determine the cost and the budget for those, and that has been their job. So how do we make this work? Well, the way to make it work is you amend the master declaration and identify that we're going to start a second condominium here. It's going to be whole ownership. We're going to identify that what for most of the common elements in SK1 will now be shared area expenses, and that SK1 will still have the right to manage and operate those. And so when they amended the first declaration, in underlined language on paragraph and page 3 They said the fractional association shall be responsible for the maintenance, operation, repair, replacement, and refurbishment of all shared areas, which are also common elements of Condo 1. So that set the stage to restructure and explain what this resort was going to do. And there was a lot of discussion from the appellant that this is an unfair scheme and it's the wrongs must be righted. No, that's just not accurate. What is entirely left out of that argument is the fact that this was very well known to every single purchaser in SK2, because when the SK2 declaration was recorded on November 30th, 2011, on page 1, there is a bold and capitalized paragraph. I've never seen this before in condo declaration. And it says, most components that are typically common properties of development of this nature have been declared as common elements of the fractional condominium and designated as shared areas pursuant to the master declaration. Pursuant to the master declaration, the fractional association has the responsibility to maintain the shared areas. Bold, capitalized, page 1. It's also on page 29. And then before any units were sold to any one of the owners, they signed a receipt. They got the master declaration, the First Amendment, and the second SK2 declaration. But more than that, every purchaser also signed a statement of understanding. And that's in the record in pages 2167 to 2169. But the very first line of the statement of understanding said the developer desires to eliminate any possibility of misunderstanding as to the information that might have influenced your decision to purchase. They acknowledged that they had read the condominium documents, they'd had the chance to talk to the developer, and then they specifically initialed that exact same bold and capitalized language in their statement of understanding. So there's no scheme. What happened is the purchasers in SK2 made a decision, a fully informed decision. We are going to buy this condo, this whole condo. We're going to buy this bundle of sticks. And the only little bundle of sticks they didn't get, the whole heart of this claim is that they didn't get the right to operate and manage the shared area expenses, but they bought their interest knowing it. And so when you look at this plan of development...
Well, just to kind of tie into something I discussed with counsel for the appellant, you would agree then that insofar as you can't deprive SK2 owners of shared area, common elements, whatever you want to call it, you can't deprive them of that, especially insofar as, we're talking about the hallways that lead to their places.
Absolutely.
That if your clients were to ever enact or attempt to utilize the reserved powers that they have, basically, in a way that violates the Condo Act, they could be opening themselves subject to litigation on that discrete act. Would you agree with that?
I think so, and that would be an unfortunate situation, but I think so. I mean, the decision by this court to affirm the governing documents here and to not completely change the plan of development, depriving SK1 owners based on the governing documents, which is what we're dealing with as a challenge to the existence of these entities, does not mean they get to run roughshod over SK2. And that threat is a viable one, it's an unfortunate one, and it's a reality, and I hope that we never get to the situation where someone gets sued every week, but I suppose that possibility is out there. There's a deterrent on both sides, but that possibility exists. But that doesn't mean that they've reached the point of challenging these governing documents, because this is not a situation where the four of us buy a home in a subdivision and you get to mow your yard how you want and you get to build the swimming pool you want and I get to park where I want. Condominiums are extremely different forms of ownership. The Woodside case tells us that they are creatures of statute. And the reason that courts and the Florida legislature are so protective over the governing documents is because when the SK1 owners purchased their units, they purchased knowing they had this bundle of sticks, and they never expected that a subsequent purchaser who had knowledge of the plan of development would be able to take some of those sticks away. And I used to hate the term bundle of sticks, but it's really appropriate here. If you start pulling away their ownership rights, that's not what they bought. And so when the Grove Isles court, which is a third DCA opinion in 2014, looked at a challenge to the governing documents, it said new unit owners purchase their units subject to the provisions of the declaration. This presumption, the presumption that the governing documents are clothed with a very strong presumption of validity, arises from the fact that each individual unit owner purchases his unit knowing of and accepting the restrictions to be imposed. Such restrictions are very much in the nature of covenants running with the land, and they will not be invalidated absent of showing they're wholly arbitrary, violative of public policy, or that they abrogate some fundamental constitutional right. That is an extremely high standard, and that has not been met here. And I know that counsel wants to argue about fairness and reasonableness, but courts have looked at use restrictions, and they've determined that a certain amount of unreasonableness is okay when you know what's going on. We cited the free unit holders of outdoor resorts at Orlando case, and that's a case that this court opined on in 1984. And there, the use restriction was that the developer had a 99-year exclusive rental provision over the lots. It was an RV property, but it was still a condo. And the developer actually had a 99-year exclusive rental provision where if you were not at your lot, it could rent it out. So if you talk about the bundle of sticks being ownership, enjoyment, use, and being able to rent, for 99 years, that wasn't your choice. And this court said that the appellants had failed to carry their burden, that the provision was unconscionable and unenforceable. Recording of the declaration gave each potential lot purchaser at least constructive knowledge of its contents. We're even stronger here. We just went through that they got all these documents, they knew about them. They have the full ability to rent, own. They have the full ability to rent and own and use their property. The only thing they're complaining about, and their complaints are numerous and long, is that they don't have the right to operate and manage the shared areas. They have every other use right. And I thought Judge Lucas brought up a good point. Many of the things they complain about, they claim that the trial court didn't address all their issues. The trial court did. What the trial court did is it highlighted the issues that they raised, statute of repose, it looked at 718-302, it looked at all those things, and it made a decision that you've requested relief. The only relief they requested was a merger of the two condominiums. By the way, they didn't get consent even from their own owners. They never even attempted to vote for the merger. And they asked to create a master association and push these two entities into it. And the court said, there's no legal or factual basis for that. The court didn't go through allegation by allegation. You mentioned paragraph 61 of the third amended complaint, but it didn't address every single allegation. I've never seen a court do that. But the court said, you've asked for merger, you've asked to create a master association. And Judge Lucas, you correctly pointed out, that's the only relief requested in all four counts.
Can you address the application of 718-302?
Absolutely, Your Honor. It doesn't apply, very simply. 718-302 is a statute that the title of it is agreements entered into by the association. That's the title of it. And it's really the heading for what it is. It's not a catch-all statute that we undo things done by the developer in the declaration. And there's no case in the state of Florida, and I haven't looked elsewhere, but there's certainly no case in the state of Florida that has allowed a member of an association to use 718-302 to undo something done by the developer. Rather, the only cases cited by either party on 718-302 are cases where an association after the fact has attempted to change or terminate a contract or a lease or a declaration done by the developer-owned association. So that's why the title is agreements entered into by the association, and that permeates every provision of 718-302. Specifically, the 2000 Condominium Association case, 513 Southern 2nd, 1324, it's not dicta. It was a question of, can the association cancel certain recorded easements granted by the developer prior to the creation of the association? Similar to what we have here. We have things done by the developer before SK2 was created. And that court, not in dicta, said that 718-302, quote, only permits cancellation of any grant or reservation entered into by the association rather than as here the developer. But that's what appellants are trying to convince this court to do. Say that something the developer, as opposed to the association, did and trying to undo it. That's not what the statute is for. In other language, that court said 718-302 is clearly only directed toward contracts for vending machines, management, and the like. It's a statute where if the association controlled by the developer enters into a management contract that the association doesn't like, once turnover happens, the association can make the decision to terminate. So 718 in its entirety does not apply. The one thing I really do want to get to just briefly, because Judge Lucas touched on it, is the statute of repose. It's easy to say that I'm not jaywalking as I'm walking across the street in the middle of the road. I'm not jaywalking. That's kind of what we have going on here. If you look at the amended complaint, the first effort by SK2 to undo this scheme of development was to say that it was not lawfully created, that it wasn't built on, quote, land, there weren't common elements, And it asked the court to declare that SK2 was not created. By doing that, it would then become part of SK1 and it would have the rights it seeks. The fifth version of the complaint, what we see in the Third Amendment complaint, it's the exact same thing. All of those allegations are still there. We still see that SK2 wasn't created on land, that it didn't have common elements, neither of which is true. They're belied by the governing documents. But those allegations are still there. They named every single owner, they named all the mortgagees, they named all the associations, which is required by 718.110.10 in order to have that sort of claim. They claim that they're no longer pursuing that, but they are. They didn't dismiss those defendants. If you look at the allegations of every count, they reallege and incorporate all of those allegations about land and common elements. If they're not doing it, what they should have pled was, we admit that the condo is effectively created, we challenged the governing documents, and they would not have reincorporated all of those grounds to say that it wasn't validly incorporated. So while they say they're not attempting to find that the condo wasn't validly created, the documents say different. And I think Judge Lucas pointed out properly that even if they're not actually doing it, what they're effectively doing is they're going to destroy the existence of SK1 and SK2. They're going to create a new master association or merge the two.
Mr. Carlson, you are at 15 minutes.
Thank you very much. I suppose I should state my request would be that the court affirm the final summary judgment.
Good morning. May it please the court. My name is Lori Heim. I am here this morning on behalf of the Appellate SK Condominium Association, which has been referred to as SK1 in the answer brief. I wanted to address the point raised by Mr. Lobeck when he began his argument this morning that the plan of development and the governing documents create an extraordinary injustice. On that issue, we disagree with that argument. The fundamental reason for that is that there was record notice for every single owner that purchased in this development. All of the SK1 owners were on notice of their rights at the time that they purchased their units, and then 2 or more years later, when every SK2 owner purchased their units, they were on clear notice. I don't want to reiterate the point that Mr. Crossland raised with regard to the clear language in the SK2 document, but he repeatedly referred to the bundle of rights that each owner was aware of at the time they purchased. For that reason, the fact that everyone that owns any interest at that condominium has notice of what they purchased weighs directly against the appellant's argument that there is an extraordinary injustice here. As I raised in the answer brief initially, the shared area budget is what this case is about. SK2 has every single right that it is supposed to have in its association. It does not.
I think what Mr. Lowe would say is, listen, we are basically captive to a quarter of the building. They could, in theory, decide, you know what, we want Palatine, beautiful oak-lined hallways, and we've got the power to assess, and off we go. And you have no say-so in it. It will be a valid lien. It will be a valid assessment because we got sole power to do it. I think that's the concern.
I agree.
I'm obviously overstating, but I think that's in that vein is where the concern is.
I agree, Your Honor. The master declaration provides that the shared area budget will be prepared in consultation with SK1 and SK2. So I think that mitigates the first that issue to an extent. But, Your Honor, the issue that you raised, is it possible that going forward, if that, for example, were to happen, does SK2 have the legal right to bring a cause of action against SK1? I think the answer to your question is yes. There is absolutely the right going forward if SK1 violates...
On what basis? What would they argue?
Well, SK1 has to create a budget that comports with the unit as it exists. You know, what is necessary. The SK1 declaration clearly lays out, as does the master.
See, if I'm on your side, if I'm a lawyer and I get that lawsuit, I make the exact same arguments in that context as what you're making now, which is, hey, these people bought eyes wide open that we can do whatever we want here. We have sole budget-making authority. Go away.
I don't believe that my client, SK1, would have the right to argue that. I think there can't be, there's an unreasonableness at which SK2 would have the right to challenge the budget. Moreover,
you got to take that unreasonableness and you got to put it in a cause of action. You got to put it in a silo that properly gets before a circuit court. What is that?
Well, I think you have a plan of development and a scheme of how the building operates and looks and works to go.
And that scheme is that your client has sole budget making over the shared areas.
Well, in consultation with SK2, but also I think from a practical standpoint, SK1 has to pay for those as well. So does SK1 really want to go adding marble and things like that? I mean, it isn't as if
they only carry a quarter of the freight.
Well, they still carry part of the freight, Your Honor, so it's not as if they don't have skin in the game on that issue. But again, our time is coming to a close, and I think perhaps Mr. Peterson, perhaps not. But in any event, I do think there is a remedy. I don't think that this court needs to create a decision here that in the future, governs in the future and essentially destroys SK1 and what my clients purchased.
Good.
Thank you.
Slow, you have 5 minutes.
Thank you, Your Honor. The plan was very well known to the SK2 owners, so it's alleged. I don't know every condominium purchaser that reads and fully understands everything that's in the documents.
Brief, it's a complex instrument. They're always complex instruments.
Yes.
If we rely upon that, though, that means that there's no point in doing disclosures, and disclosures don't mean anything because it's a big complex instrument.
It's not that they don't mean anything, Your Honor, but I would draw your attention to 718-303-2. Another provision of the Condo Act I wrote when I was with the state in the late 70s that prohibits anything in condo documents such as this which would waive the rights of the unit owners provided in the Condominium Act. You simply can't have a totally illegal scheme, as I think we've demonstrated here, and excuse that by the fact that people are on constructive notice or even arguably actual notice. You have to look to see whether the scheme is lawful and equitable, which I think beyond any shadow of a doubt this is. Not simply that people bought into it. And as we allege in the complaint, what prompted all this was sharp escalations in the assessments. Not by SK1, they don't have the power, by the developer. Your dialogue with SK1 suggested they had the power. There's been no delegation, and the record is devoid of that. So our concern is that expenses that shouldn't be shared area expenses are being shifted over to us. We have no ability to scrutinize the records to determine whether that's true or not without litigating every budget, every special assessment, every lien. It's untenable. And indeed, if there were to be specific lawsuits on specific things, this case would be referred back to, as Your Honor prudently observed in your questioning just now, and say it's legal. We have a right to do this. You're without a remedy. You know, you can say it's unreasonable, but where's the standard for saying that case-by-case application, as you indicated in the previous case, has any merit with regard to your ability to say it has to be reasonable? It doesn't have to be reasonable. And with the Grove case, which has been cited a couple of times by Mr. Crossland, he said something in the documents has to be given deference unless it's wholly arbitrary or violative of public policy or unconstitutional. We suggest to you that these provisions that we've brought to this court are wholly arbitrary and are violative of public policy. Public policy as legislated in the Condominium Act, where owners have rights. We're not blindfolded and gagged and have no control over our destiny. You know, for these large assessments, living in a condominium where we own 75% of the units and have zero rights. Again, this is an extraordinary case. We're asking for extraordinary remedies. We're asking you to remand this back to the trial court to work with the parties to craft articles of incorporation for a master association, which will be fair, which will be equitable, which will comport with the law, merge the condominiums, simply merge the associations without merging the condominiums. Those are the three alternatives that we have in our pleadings to set this right. Rather than say that this unlawful, grossly inequitable scheme comports with the law, comports with equity, and any developer in the state can start doing it, and depriving the large majority of the owners any rights as condo owners, leaving them slaves to a scheme that maybe they were on notice of, but nevertheless is unlawful and cannot be implemented, cannot stand. We've cited many cases saying that provisions in a declaration which are contrary to state statute cannot stand. And I think we've done that. We've made an attempt to cite every legal theory possible. 110.10, you don't like it, we've got other things. The statute of repose doesn't apply, even as we've demonstrated to our 110.10 arguments. So this is an important case, Your Honors. Hope you take as much interest going forward as you've demonstrated today. It's a matter of important public policy to set it straight in the law that these statutes mean what they say. A grant in a declaration must be fair and reasonable. It cannot violate the rights provided to condominium unit owners by the Condominium Act. And all of the other remedies which we've sought to bring forward, or basis for a remedy that we've sought to bring forward, you had your choice. We think they all apply. If you find one applies, then you have the ability to send this back to the trial court to fashion an equitable and lawful remedy to this arbitrary, capricious scheme that's been forced upon my clients. Thank you very much.
Thank you all.
Thank you.